Okay, so I'm going to talk about the international standards regarding treatment and care for people with drug use disorders who are in contact with the criminal justice system. And obviously, we know that drug use is a health issue, or at least we should know. And there are many ways in which this group of people can come in contact with the criminal justice system, either because criminal laws are such that they actually criminalize the use of drugs themselves, which they should not because it's a health disorder, or because those people related to their addiction or dependency commit criminal offenses that are not per se drug offenses like theft, or because they come in contact with the criminal justice system for more serious offenses. I will limit myself to the international standards because we will have the pleasure to hear about some specific country examples from another colleague. So what I want to focus on is different sets of international instruments that are important to consider and that share one common denominator when it comes to people with drug use disorders. The first set of those standards or instruments are the International Drug Control Conventions, which deal mainly with measures that states should take to limit the use of narcotics and psychotropics to scientific and medical purposes. And part of this is using the criminal law. Another part of this is using health and preventive measures, as well as administrative measures on control. The second set of instruments comes from international human rights law, which includes instruments like the International Covenants on Political, Civil and Political Rights, or the Covenant on Economic and Social and Cultural Rights, which most countries have ratified, including, on the one hand, the right to health and other issues, as well as important when we are talking about the criminal justice context, rights relating to personal liberty and fair trial. And thirdly, third circle that you see at the bottom is the international standards and norms in crime prevention and criminal justice, some of which have already been mentioned, like the Beijing rules for children and the Bangkok rules on gender-sensitive approaches. And I want to reiterate the importance of the Tokyo rules, which is an instrument on non-custodial measures in general, but it is also very interesting to consider in light of this specific topic when we talk about people with drug use disorders. And then the circle that you see on the slide that is green, that is called International Standards for the Treatment of Drug Use Disorders. That's a body of also standards, but not necessarily normative ones. It's based on evidence, on good practices. And it's something that has been developed by the World Health Organization and by our office based on evidence and consequently subject to change. And that's about how treatment should be implemented for people who have drug use disorders. And that comes into play when we're talking about how to implement treatment programs that might be available as part of alternatives to imprisonment or as part of any community-based health treatment that is available for any drug user. Looking at the International Drug Control Conventions, it's important to mention that they envisage, as I mentioned, different types of measures for people with drug use disorders, ranging from prevention to treatment, as well as education, aftercare, rehabilitation, and social reintegration. And it's important when we're talking about alternatives to realize that the conventions specifically allow for those measures to be applied as an alternative, either to conviction or to punishment altogether. And this is not just the case for drug consumption offenses. There are three mentioned in the conventions: cultivation for personal consumption, possession for personal consumption, and production for personal consumption. But this is also possible and explicitly allowed in all kinds of other drug offenses, including drug trafficking, if they are considered a case of a minor nature. And that is something obviously for the judicial authority to determine. Looking at the second body of law, international human rights law, I already mentioned the right to health, the right to personal liberty and security, fair trial and due process rights, but also another important right to consider is the right to be free from torture and from cruel, inhumane, and degrading treatment. And in that regard, it's important to mention that it's an explicit requirement that no one should be subjected against their will to medical or scientific experimentation, which is a point we will come back to. In terms of UN standards and norms in crime prevention and criminal justice, I mentioned the Tokyo rules that apply in general to the non-custodial measures, as well as the Bangkok rules, which we've heard from Sabrina just a moment ago. And one of the Bangkok rules, number 62, is in fact talking about the duty of states to provide treatment for drug use disorders that is gender sensitive. And that means it needs to be trauma informed. It needs to have a possibility of women only settings, and it should be complemented by measures that facilitate women's access to such treatment, both for diversion and alternative sentencing purposes, as well as for crime prevention. And taking all of these principles and rules together from these different bodies of law, we have actually published together with WHO a handbook that summarizes the relevant rules in relation to the treatment of people with drug use disorders benefiting from alternatives to conviction or punishment. And there's 7 principles that we can identify summarizing all of the relevant rules, which I hope you have read or will read in detail. So I would like to present to you these 7 principles. Number 1 is that drug use disorders are a public health concern, which requires consequently responses that are health-centered. And that means in particular that individuals should not be punished for their drug use disorder, but should be provided with appropriate treatment. Secondly, the use of alternatives to conviction or punishment should be encouraged at all stages of the criminal justice system for those offenders who have drug use disorders. And it should be based on an assessment of established criteria. And in this regard, it's interesting to look at the Tokyo rules, because the Tokyo rules stress that relevant criteria are not just those related to the offense that we often find in laws. Because of this offense, this measure applies, but it also should include criteria that relate to the offender, to the personality and the background of the offender, as well as to the rights of the victim and society. And in case of people with drug use disorder, these personality and background criteria are very important in order to look at why someone entered in conflict with the criminal justice system. And often it's because of an addiction, a health concern, and not because of a particular malicious intent or a desire to harm society. Alternatives at different stages means that there's not one measure that fits all cases. Often we have in mind, in thinking about this topic, the measure of drug courts, which comes at the sentencing stage or trial stage, but it starts actually at the police stage, at the prosecution and investigation stage, and also goes beyond the courts into the prison and probation stage. So you see these different arrows that symbolize that alternatives for people with drug use disorders should be considered and should be available at different stages, starting with police being trained to recognize and able to divert them if it's appropriate. The third principle is proportionality, which is really important at all stages of the process. And that starts with matching the gravity of the offense to the response. So punishment should be proportionate. The interventions of the criminal justice system should be proportionate. The Tokyo rules talk about the minimum intervention principle. There should also be proportionality in the implementation of alternatives in terms of what conditions are applied and how well those conditions meet the needs of the offender, as well as when we respond to non-compliance. So often you have these tests, urine tests, and if someone tests positive, then automatically they're sent back to prison, deemed to have failed the treatment. But actually we know from science that it's quite normal to fail the test. It's part of the recovery process. In order to heal, in order to recover from this health condition, failure and relapse is quite common, and it's considered a normal part. So in that regard, we need to have responses that are proportionate also when it comes to dealing with non-compliance. The fourth principle is that diversion to treatment should always be made with the informed consent of the offender, which is a medical principle, but also a justice principle when it comes to measures at the pretrial stage, where the presumption of innocence still applies. The fifth principle relates to all kinds of legal and procedural safeguards, which includes the conditions established, the duration of the measure should be established in law, the rights of offenders in terms of dignity, human treatment, the possibility of an appeal, judicial review, as well as other safeguards. And another important principle, we've heard about different groups, and also in this regard, people with drug use disorders are not all the same. Specifically, women have very different patterns of drug use. You will find that in our Uondc World Drug Reports. There's a special edition from 2018 that talks about the differences between men and women when it comes to drug use. And you will see that reading that chapter, the responses and the types of treatment that needs to be provided are also quite different. And finally, last but not least, those people with drug use disorders that cannot be released, or that in cases where it's not appropriate to use alternatives to imprisonment, we still have to consider that prisoners may not be deprived of their right to health, and they're entitled to the same level of treatment as the general population. We find that provision in Nelson Mandela Rule 24, the principle of equivalence, and that it applies in respect to any health issue, including treatment for drug use disorders. If you want to read more about what I've said, considering that we have limited time, please use these tools. There's links in my presentation. I'm sure it will be shared with all of you. On the left-hand side, you have the joint tool that we developed with the World Health Organization on this very topic, and on the right-hand side, the more detailed standards of evidence when it comes to how to implement drug treatment programs. Thank you very much, and I look forward to the discussion.